Today we're answering the question, how does the probate process work? While the process can vary from state to state and is often subject to outside factors that can certainly change it, I'm about to give you a very simplified step-by-step description of the probate process. Hey, I'm TJ with Probate Property Advisors, and I'm going to explain what probate is and how it works. So how does the probate process work? As I said before, this can vary from state to state and even from county to county. So today I'm just going to give you a brief overview in general of what it's all about. And we're always available to answer questions. We're just a phone call away to explain anything in these videos that needs further explanation. Probate process all starts with an original, signed and executed copy of the will. It's delivered to the local probate court or whatever court supervises probates in that area. A notice of the petition for probate is then published in a local newspaper, and this usually is a requirement prior to the formal appointment and or certification of the personal representative, sometimes known as executor or executrix. That would be the person who is named in the will. Now, assuming a will exists, it's referred to as testate, or if the court has to appoint administrator when there is no will, that's referred to as intestate. So after the certification or the appointment of the personal representative has been made official, they then file for the formal petition with the court to probate the estate. Following that step, and generally for a legally specified period of time, 4 months can be typical from the date of the public notification of the petition for probate, creditors against the estate are then allowed to file their claims. This includes any previously unpaid debts, other liens or judgments, debts resulting from medical care, funeral expenses, outstanding taxes, and other encumbrances. During this same period, the personal representative will be working to identify, gather, and secure the assets of the estate in such a manner as to be able to ultimately distribute them in accordance with the will or court directives. To accomplish this, the personal representative will also need to locate and access all bank and other types of security accounts, determine any of the remaining debts owed by the decedent that require settlement, determine any real property or properties owned by the decedent, and secure the titles to these and other assets that will ultimately need to be disposed of. It's also the responsibility of the personal representative to maintain these assets safely, properly, and in good condition during their period of stewardship, as well as collecting any income, such as rents, residual interest payments, etc., that are due to the estate. To do so, the representative must be aware of and maintain proper insurance coverage, protecting the assets from theft, damage, flood, fire, etc. The personal representative may also, if permitted or desired, liquidate some of the hard assets, such as cars and real estate. This is often done to provide cash required to compensate the creditors. When the formal claims period has expired and all assets have been collected, property that needed to be sold has been sold, and assuming no problems have arisen, such as a contesting of the will by any of the heirs or other contested claims against the estate, the personal representative will usually file their final petition with the probate court to allow a complete distribution of all the remaining assets to the heirs and beneficiaries. This final petition includes a detailed accounting to the court explaining all of the expenses incurred, funds and assets received and dispersed, how assets were invested or otherwise used, and the proposed final plan for the final asset distribution. Assuming the court approves this petition, the personal representative then distributes the assets as instructed in the will and detailed by the approved petition, and or as required by law or the courts if there was no will. Okay, so that's the process in a nutshell. Now, the next question you might be asking is, how long does the probate process usually take to complete? And the duration of the probate process is subject to lots of different variables, but a general rule of thumb is approximately 6 months. However, you should be aware that it can and frequently does take far longer. Some of the matters that can delay the completion of the process include problems in locating the heirs and beneficiaries, a contest of the will or disputing the validity of the document by the heirs or the beneficiaries, claims or liens against the estate that remain unsettled, real estate or other property that cannot be sold for some reason, failure to properly notify one or more creditors during the claim period, dissatisfaction regarding the actions of the personal representative by the heirs or beneficiaries, The complexity of the tasks and the myriad of possible delaying factors make it imperative that a well-organized and meticulous personal representative be selected, someone who can effectively manage the process and reduce the chances of complication and delays. So another question you might have is, why is probate actually required? And there are many reasons for probate, but some of the most important are transferring the legal title ownership of the decedent's property and assets to the heirs and or beneficiaries. Generally, if there is no property to transfer, then there's usually no need for probate. Other reasons are the collection of any taxes due from various taxing authorities that might be owed by the decedent or his or her estate at the time of death, or taxes that become due when a property is transferred. As I stated before, probate also provides a legally mandated deadline for creditors to file claims against the estate. This prevents old or unpaid creditors from future claims against their heirs or beneficiaries. If the deceased owned real estate in his or her own name, no one could properly accept title to that property, nor would a bank give a mortgage to a new buyer unless the estate went through probate and a clear title could be given to the new buyer. Finally, it provides a legal method for the actual physical distribution of the remainder of the estate's property to the heirs and beneficiaries. So for more information on probate and real estate, make sure you hit the like and follow button, and we will see you soon.